All right, we are live. Before we begin,
this meeting is being transcribed.
There we go.
This meeting is being recorded.
Just another reminder that if anyone in our audience or visiting us online, when we get to the public comment section near right before the legal report, please just indicate that if you wanted to speak about something related to the agenda in the chat box. And then that'll be, if you're attending virtually, that'll be our signal to give you that opportunity. And anyone here in the that's behind me that wants to sign in, please do that as well if you were wanting to speak to the board when we get to that point. Other than that, Chair, we are free to begin if you're ready.
Yes, we are. Very well. Notice of the February 15, 2024 meeting of the Board of Examiners for Land Surveyors, including the date, time, and location, has been noticed to the Land Surveyors website since July the 5th, 2023. Additionally, this month's agenda has been posted on the website since February the 8th, 2024. So that brings us to the roll call.
Thank you, sir. All right. Jay Kaufman?
Here.
Gary Clark?
Here.
Kevin Martin?
Here.
And Justin Raines.
Here.
All right, Chair, we have quorum. Looks like we're ready for the agenda.
Motion for approval?
Yes.
So moved.
Second. All in favor say aye.
Aye.
Okay, then we have the November minutes. Has everybody gone over those? Is there any changes or corrections or edits that need to be made to those?
Hearing no changes or edits, I move we approve the minutes from the last meeting.
We have a motion. We have a second.
Second.
All in favor say aye.
Aye.
At the professional society report. The professional society report. We have Jimmy on the phone.
Good morning. Can everybody hear me?
We hear you, Jimmy.
Okay. It's on our end. It's a little choppy, so I just wanted to make sure. Good morning. Appreciate the opportunity to attend virtually. Just a brief update on what's going on with TAPS. Everybody's getting ready for our conference coming up in the next couple of weeks, March 7th through the 9th. We've got a good program lined up with good speakers, and look forward to seeing everybody as we do every year. Looking forward to that. Looking forward to a good conference. As many of you are aware, TAPS has introduced some proposed legislation to kind of clarify some confusion with the current licensing law and kind of streamline the process for becoming a licensed land surveyor. That was introduced, and the House bill is 2235. The Senate bill is 2584. Last update that I got from the Bivens group is that those bills are moving through the respective committees, and just awaiting some feedback from the Bivens group after those committee meetings this week. That's most of what I've got to report on.
Thank you, Jimmy. Questions to Jimmy from the board?
Hey, Jimmy, real quick, you mentioned the House bill, Senate bill. Briefly, can you give us an idea of what's contained in there?
I don't have the text in front of me, but basically what we're trying to do, the biggest things we're wanting to do is clarify that, or request that the applicants or applicants' experience count from day one of their employment. That the all the time is basically under the direction of a licensed land surveyor. It streamlines the process for Category 4 and Category 5, basically removing those grandfather dates, and that was extremely confusing. It removes the requirement that your experience does not start after you pass the FS exam. It basically starts, first day of employment as under a practicing land surveyor. It increases the education experience in Category 5 from 12 hours to 18 hours, and it reduces the time in Category 5 from approximately 16 years down to 10 years of progressive experience. So that's kind of it in a nutshell. I apologize. I probably should have had that text pulled up, but that's kind of a brief synopsis of the proposed changes.
Very good. Thank you, Jimmy. Hey, back on the TAPS conference, I know that
Yes, sir.
for the past couple of years, the board has had an opportunity to kind of present as a seminar, what's going on with the board. I'm certain that we're on there again this year. Do you have the exact date and time just offhand? I know I caught you cold-handed there.
If you could give me just a second, I can see if I can pull that up. Okay, I've got it pulled up in just a moment. Tennessee Board of Examiners from 1 o'clock until 2:50 on Thursday, March the 7th.
You said Thursday?
Yes, sir. Thursday from 1 o'clock to 2:50.
Very good. Thank you.
Yes, sir. Thank you.
Anything else for Jimmy?
Nope.
All right. We'll move on to the education report. Hello. Can't figure out whether I'm on or not. Okay, if you all guys now review this, see what the new reports are. Thoughts or comments on that?
I don't. I've reviewed probably most of these, and obviously have approved them. I'm sure my counterpart has done the same. I think we have a total of 10, all with the recommendation of approval. I make a motion for approval of those listed.
Second. Further discussion? Hearing none, and all in favor say aye.
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 Well, we pass those. That brings us to an application review.
Okay, I'll just sort of give you a quick synopsis to sort of set it up and for your discussion and for your consideration. Of course, you've seen the application and the request. We're looking at this individual. He's 59 years old, so he's not eligible for the exemption under 0820-05-091C, but is eligible under 1A, which reads, and two parts or one part with a subpart, says, notwithstanding any other provision of this chapter to the contrary, the board may exempt a registrant from complying with all or part of the continuing education requirements for a given year in the following cases. And then part A, for which he's eligible, would be as such: a registrant affected by a physical disability, illness, or other extenuating circumstances as reviewed and approved by the board, provided that adequate supporting documentation is furnished to the board. I do have the doctor's report. It does coincide with the redacted the redacted document you have in front of you. So if you had any additional information that pertains to that, obviously what can be permitted per HIPAA and the rest, that's why it was not included. But it does validate that the fact that there was this legal arrangement that you see before you now. And we're looking at 15 hours given, it's per given year, so that would be the 15 hours, not the full 30.
So kind of a question on this, and not pertaining to this case particular, but the topic of the exemption rule. So the exemption is for the PDHs. Does it allow the registrant to continue to survey under his license? Is it still considered active and license, and he can continue to survey even though he applied for an exemption on the PDHs?
No, because once they're in expired grace, which this individual would be, because they can't attest that they've completed their 30 hours because they haven't been granted a waiver until today, unless if the board decides to do that. So they still owe us 30 hours, period. And so come December 31st, they have to attest by otherwise to that full amount. Otherwise, they go into expired grace. Expired grace is simply that you're expired, so you don't have a license. Grace means you don't have to reapply. So grace, a lot of times folks will confuse the grace period to assume that they can still practice. Well, yeah. So it's an expired grace right now. And if he was granted the 15-hour waiver, if the board so chose to do that, then he would just have to, he'd have to give us the other 15 hours. But there's some online offerings as well, and he could certainly do that. But that doesn't appear at this point that he would be in a state to even practice.
No,
you know,
and I was not referring to this particular.
Yeah, but
just,
right. Yeah.
Okay.
So I understand that, and so for any individual who applied for this type of waiver on hardship, all it really does is keep them from being expired and have to reapply, and just delays when they have to take the hours. They still have to take the hours.
Yes, sir, that's correct. Well, when I say if they get a waiver, that's a true waiver.
Okay.
Like that 15 hours, they don't owe that waiver for this renewal cycle. But you know, we still have the balance of the 15 because they're only eligible up to 15 hours in a given year, and so they would still owe us 15 hours at that point.
It's really just there are 15 hours that can be waived, and they don't owe that back to us. While they have to understand that they can't practice, they still have to get.
If they're an expired grace, they're expired, so they wouldn't have a license. That would be unlicensed activity until they renew. And you know, it's very. I mean, obviously, depending on what the circumstances, you know, it's better to have that request brought before the board prior to them entering an expired grace, so that we can apply whatever waiver if the board wants to afford. But you know, after the fact, they are an expired grace, and that's just the status of their license at that point. So,
in any case, all we're really doing is saying when they get ready to practice, they don't have to reapply. They just have to catch up.
That's correct. Yes, sir.
Okay. Very well. Thank you.
That's a beautiful, you know, that's a beautiful provision in the statute, because if you had to reapply, you know, that's a whole nother kind of bag. I mean, obviously, we're not going to pretend we've never seen you before. If we've got your stuff on file, and we would, then, you know, you just pick up where you left off. But references, all that kind of stuff, you know, it comes to play at that point.
Any other questions on that?
Well, I do have to say that on this particular topic that we're discussing here, I do applaud I guess it's the conservator, the executor of the estate here, who has gone to this extent to protect his father's, I think, license. So I applaud him for that. I mean, that's quite a bit there's a lot of paperwork in here, and there's a lot of time and effort and expense involved in all that to get to this point. I would make the assumption that a lot of people, if not most, in this particular situation probably wouldn't go to this extent. So kudos to him for going to this extent and covering the base there. I did read through the rules as we have them in there for exemption of hardship. I certainly think this qualifies. Good gosh. I'm not privileged enough to know the registrant here, but I certainly sympathize and empathize with his situation there. But as far as I can tell, he certainly has covered all the bases. And as far as the application goes, I'd be willing to make a motion for approval of the application of exemption based on hardship.
Second. Further questions or discussion on that? Well, I agree. I'm glad for the explanation to clarify exactly what that does to it. Sounds pretty fair. All right, hearing no other requests for discussion or questions, we have a motion and a second. All in favor say aye.
Aye.
Aye. All right, and that passes. Which brings us to the director's report.
All right. Let me get there myself. All right. Don't have a big heavy lift today. Looks like I'll save that for Erica coming up. But the budget report's all I've got for you today, and that's informational. There's no action items here. Just to go over some key things that stood out to me, and I figured if they stood out to me, they probably stood out to you too. So we'll just go over them. If you have any other questions, then we can follow up on that as well. All right. So at the last meeting, we reviewed the reserve balance and line items for previous fiscal years and financial reporting through September. So as a result, we only have 3 more months of record. So we're primarily going to be looking at October through December. The October budget line item under technology was our share of a rather large expenditure billed to reg boards, writ large, for some core enhancements and work that was provided across programs. So I'd look at, that's one nice thing about having some other programs. You can check trends, not just within your own program, but vis-a-vis other programs. So that was helpful. And, having already identified that in A&E board and then check to verify that it was the same here, it was. So that's a core enhancement there. Of course, you can see the shift when renewals opened for revenue. This is and that was pretty substantial. You'll see that it just kind of jumps off at the page right there in November. Obviously, the November 1, those renewals open up, and so you see immediately what's happening there. So that's pretty obvious there. And of course, it flows down to our net surplus now, which is it's our renewal year. So we should be in the green at least this year, and every other year we'll be in the red. That's just that's how it works for us. But and we anticipate that and expect that. And if you're wanting metrics, I can give you a little bit of that. Let's see, we've got roughly 1,050 land surveyors out of 1,130 that have renewed, with a few still trickling in. So pretty much just about everybody, minus a few, in expired grace right now. But we're still getting a few of those trickling in. So that we're not done yet. But we had a good turnout. That's what kind of what you want to hope for. So that looked good. Other than that, I didn't see anything else that just jumped out at me. If there's anything you want to talk about, I'll be happy and entertain any of that. And if I don't have the answer for it, I'll get that back to you.
I have no other questions on that. Any questions from the room? Nope.
I've got one real quick here on those numbers you gave me, the 1050 of 1130. I'm seeing 80 basically have not renewed for a variety of reasons. Is it those 80? Is that put them in the category of an automatic audit? Is that correct? Because they did not renew on time, so they're technically in addition to the 10%.
Yeah, no, they haven't renewed, so they don't have a license, and so
right.
That we wouldn't audit them at this point. And we wait for our audit. I mean, we're not gonna, I wouldn't give all my secrets, but we make sure that it's a wide net, So we're gonna make sure that we loop in all those folks. Okay. But so we're in no rush to do the audit immediately, is what I'm saying.
Okay. In terms of no rush to do the audit, is that of the 80 that haven't renewed yet, or is that inclusive of the 10% random selection for audit?
Basically, when we decide to do the audit, it'll incorporate everyone that's renewed and attested that they had those CEs. If they haven't attested and they haven't renewed, there's nothing to audit because they don't have a license and they haven't done the CEs, so there's no conversation. But everyone that has renewed and has attested to completion of those CEs, they will be a part of that audit.
Are we still 10%?
Yes, sir.
Is that right?
Mm-hmm.
Yeah. Okay.
Yep.
Okay. Good.
And just to kind of update too, it was February of last year. This board agreed to do a agreed citation schedule, so to not clutter up the legal report. Plus, it just expedites that, so they'll get, if they can't provide proof of those CEs within the time specified, then they'll automatically get agreed citation. So we're not delaying or dragging our feet on that. We just process those out. And it'll save the board some money too, because then those aren't legal fees that we're paying either. That goes to CSC. And so it's just a good cost savings as well. It just makes sense all the way around. Yeah. And consistent, which is good.
Getting back on the budget here, line items, I think I know the answer to this, but I'll just ask anyway. Obviously,
Sure.
The increased revenue November, December had to deal with the renewals. I get that, obviously. 2 lines down, the state registration fee, I'm assuming that's a percentage of income coming in?
Yeah, that's a
substantial jump in those as well. It's kind of relative to the licensing revenue that comes in.
Yeah.
Percentage of something.
No, that's a great catch. That's a reduction. How they put it? A reduction of revenue. To me, that's an accounting term, but I'm not an accountant. That accountant told me that, and what that basically means to me, it sounds like an expense. And so my thing was why not list it in the expenses? It's $5 per every license that we print.
Okay. Right.
And so so that makes sense. If you're doing that many renewals, you're printing that many licenses, it just translates. But the reason why they don't put it in a expense line item is because it's a workaround. We don't print them in commerce and insurance. another interagency, departmental agency prints those. The state prints them. It's not a vendor. Otherwise, it would show up in one of our line items. But since it's a workaround with another agency, they just charge that back to us for their efforts in that regard. So that's a.
Well, along the same lines, there also the noticeable jump on the customer service center fees. It kind of corresponds with the two November, December dates. I'm assuming that's a lot of people calling in and saying, hey, I got a question on my renewal.
You guys are getting a feel for this budget. I mean, you don't even need me. I'll just sit back and let y'all take care of it. But that's exactly what that is.
I did
right?
stay at a Holiday Inn Express.
Right. Well, that is clear. It's going to go much more smoothly then. Yeah, that's exactly what that is.
I'm good.
Right, after that, or move on.
Oh, nothing to prove, just informational purposes. But if you think of, on the drive home and you just have that burning desire, there's something came up in your mind, then just you can send me an inquiry and I'll get that for you.
All right, then before we get into the legal reports, we have time for any public comment on what we've done so far. Is that?
I'll check the sign-in sheet and see if we have anyone sign in. Then we'll check the virtual sign-in sheet as well. While I'm doing that, Alex, if you want to take a look at the chat. Opportunity for anyone in-house. All right, no one here. All right, we'll do the. Alex, who was that online that you wanted? We can. Okay. Bruce McLennan.
Yes, can you hear me?
Yes, sir. We can. Thank you.
The 80 people that you say haven't renewed, are the registers of deeds informed of these people and so that they do not record plats of any surveys done by them?
If they are come December 31st, they are January 1, they are unlicensed at that point. So that is correct. They would be unlicensed.
But are the registers of deeds informed of those?
No, they would not be. Because they still have an opportunity to license at this point. So they're going to do that at different periods. So if we're informing that, then we'd have to go back and inform them otherwise periodically. And then those are different jurisdictions across the state. So no, that we don't have a mechanism for that. However, we do have a complaint. That would be our path for anybody that was to conduct work or use their stamp should their license be expired.
Does the individual surveyor have a way of knowing who those 80 are?
You can go to verify.tn.gov and you can look up their license there, and it'll display their status. So yes, sir, that's correct.
Thank you.
Yes, sir. Did you have anything else that you wanted to bring for the board? Okay. Okay. That sounds good. Then, do we have anybody else online? All right. Hearing none, then we can move on to the legal portion of our agenda.
Thank you. Good morning, everybody. As you can see, we've kind of got a longer legal report than usual, and I imagine there will be a lot of discussion on this one. So I will go ahead and begin. Number one is 2023048591. Complainant states they signed a contract with respondent's firm to survey a property which they inherited from their mother. Complainant states their mother has paid taxes on 14.12 acres since 1960, and the tax map has matched the deed. Complainant alleges respondent refused to use their deed and claims they worked against the complainant's best interest. Complainant alleges respondent refused to stake the property boundary as described in the 1960 deed. Complainant claims respondent cited a lack of physical evidence to support the 1960 survey and produced a modified map with a reduced area based on a fence, which appears to be on the interior of the boundary according to tax maps. Complainant alleges respondent staked a right-of-way center line without their permission and without notice. Complainant further alleges this was done to satisfy the request of an adjacent landowner. Complainant alleges the final plat map included a reference to an easement describing an area outside both the boundary and their deed and outside the modified boundary provided. The subject easement was granted on an adjacent tract to satisfy a 1991 agreed order. Complainant claims respondent justified this reference by stating the easement could be construed to be within their boundary, but complainant argues it was supposed to be beyond their north boundary. Complainant also alleges the final plat map indicates an existing road within the boundary, but argues there's no evidence of a road that is visible now or in decades of available satellite, aerial, and street view photography. Respondent provided a very detailed response explaining each of the survey results and just kind of going through how they got to what the survey looked like, what the plat looked like at issue, and provided documentation to support their response. An expert review was conducted. The expert concluded that respondent sufficiently explained the complications that were involved in performing the survey and takes note that the complainant did not submit any documentation or another survey to support their claims. So the expert found no evidence of any violations, and therefore my recommendation is dismissal.
Any thoughts or discussion on that?
I did appreciate that that an expert review was requested on this and conducted. I think it's a perfect case for it. I don't think you could explain in a complaint form all the details that are going on here back and forth. The red flags to me, obviously, the first thing that came out was the tax map. That's always a red flag.
Yes.
But the fact that the expert found no evidence of violations pretty much cleared it up with me in terms of what we're allowed to opine on. So I agree with the legal counsel's recommendation of dismissal.
I agree. Surface here, it sounds like the respondent just did a lot of due diligence here and showed everything that he thought impacted the property. I don't see that there's any, and say whether or not he retraced the property line correctly, which is part of the complaint there. But from what the expert says, I don't see anything here that needs any ruling on.
Yeah, I agree. I mean, with the expert review, it seems pretty clear. Not much else to dig into here.
And a motion?
I'll make a motion to dismiss as recommendation from staff.
Second.
Further discussion or questions? Hearing none, then all in favor say aye.
Aye.
Okay, the next three came in as complaints about the same time, same day by an anonymous complainant. So just putting that out there. Number 2 is 2023056641. Complainant is anonymous and respondent is a licensed surveyor. Complainant alleges respondent and another unlicensed person are running a surveying company with multiple locations. Complainant further argues that respondent should not be allowed to run multiple locations with one licensed land surveyor. Complainant bases their assumption on the fact that respondent's website lists 2 phone numbers. Complainant alleges that respondent is in violation of Rule 0820-04-.09 and .10. I'm just going to refer to that as the rule in the next 3 because they all involve that. Complainant further alleges the person working with respondent has provided land surveying services without being licensed in the past, but they provide no further detail or any kind of evidence to support these allegations. So respondent's website states they serve Middle and East Tennessee, and depending on the job, they do drive across the state to complete any necessary tasks. The website does not display respondent's business address or refer to any address at all. Definitely doesn't refer to 2 locations. Respondent does not understand why complainant would assume they have 2 offices. Respondent did provide me with their firm disclosure and their business license. The license and disclosure are associated with one address, which is their residence. Respondent states their business partner has been doing field work for surveyors for almost 20 years and assists them with all of their field work. Respondent's business partner does not claim to be licensed and has never drafted or signed a plat All of respondents' partners' experience in the field has been under a licensed surveyor. So because I don't have any evidence of violations or, documentation or further detail to support the allegations of unlicensed activity or 2 locations, I recommend dismissal.
Thoughts?
So are there 2 different phone numbers on the website?
There
And it says for work in this area, call this number.
Yes.
And work. That's a little strange if you don't have 2.
Do we know who answers each phone? I mean, it's, my guy, mine on my hip, I have 2 different cell phones on my hip.
No.
I've seen it. Usually it's a shady business involved there, but that's not what we're talking about.
Could it be that one is a residence and the other is it like a landline versus a cell number? Or,
I didn't didn't think to ask that.
My wife has probably 4 numbers that ring to her cell phone because phones are, various answering services are forwarded to her cell
Yeah,
phone.
I mean, it very well could
Yep.
be one is their home landline since they work out of their home, and then one is their cell phone. But yeah, I agree. It seems strange. I can see why somebody would think that, but I have no evidence to support it. So, and I don't have any consumers complaining about it. I don't have any proof of any surveys or, I don't have anything really. And I don't even have a complainant to talk to. So,
Yeah, this is one of those where it seems like there's some smoke here, but your hands are really tied based on the lack of information provided from the anonymous complainant, providing really little to no evidence other than just some knowledge put on a complaint, or some assumed knowledge put on a complaint. No evidence there on the website, whether intentional or not. I don't know. Again, can't hold that. All we have is 2 different phone numbers, which there's plenty of ways you could have 2 different phone numbers and still be in compliance here. So there may be something here, but there needs to be more.
right.
And is there a way to not necessarily dismiss the complaint, but rather, if we get more evidence coming in, we could come back to it? Because I feel like if we dismiss it, then the door's shut. Boom.
Well,
But if there were more evidence to come in at a later time based on this specific complaint, that we could bring it back to action.
Well, I would suggest opening a new complaint, and then this information would be there for me to reference,
Okay, you can
and
do
I
that?
can include it in a new complaint. That way, we don't have something staying open for an indefinite amount of time.
Okay, so we can.
Oh yeah, I can always go back to this, and I would,
Okay.
that would be automatic.
All right.
Yeah, I don't, there's just nothing here really to hang a hat on. I mean, I think, one, they went to the wrong law that they stated. I think it's more over under 087D covers it closer than anything, which, addresses remote workers is fine. It's just having multiple phone numbers certainly doesn't mean that they have 2 places they're doing business. And, I'm familiar with lots of businesses whose workload is scattered all over multiple states, and where the individual employee lives is irrelevant. It's back to where is the office located, just to decide whether they're in-state or out-of-state. But particularly since surveying is not really located done in the office most of the time anyway.
Right.
We're scattered everywhere. I just, there may be something there, but they have not provided us enough information to do anything with this time. Anything else?
No, I agree with all that. I mean, if it indeed says call this number for work in this area and this number for, that's the biggest thing that's flagging. But I just don't think there's enough there to do anything about it at this point. So
I agree. That's the only thing that they may have stated more than they needed to there, but still, it's not enough there.
And I tend to think that if this complainant, who obviously filed 3 complaints, about kind of the same thing. If they have evidence, I feel like they would have provided it. If they had any kind, especially the unlicensed activity allegations, I just think, why not give me what you have, especially if I'm not going to be able to contact you.
Further discussion? Motion?
Make a motion to accept the recommendation from staff for dismissal.
Second.
Motion and second. All in favor say aye.
Aye.
Okay.
Number 3, 2023-056-631. Complainant is anonymous and respondent is a licensed surveyor. Complainant alleges respondent is acting as the licensed surveyor for a company and runs their own business in violation of the rule. Complainant provides no further details or evidence to support these allegations. Respondent states they are employed full-time with a construction company, but they are not an officer or a principal of the company. Further, the construction company does not advertise or perform surveying services for the public and focuses on industrial and commercial facilities, power and water infrastructures, mining and disaster response. Respondent they state that they execute their work for the company they work for and then their own private business as a sole proprietor from the same physical location. Respondent argues they are not in violation because of these facts. The rule states that firms, corporations, partnerships who offer to provide land surveying services to the public shall have a responsible charge. Respondent's employer does not offer land surveying services to the public. So based on all of these facts, my recommendation is dismissal, but I think there should be some discussion on this amongst the experts here in front of me because I don't know. I can see where this complainant is coming from and how possibly a land surveyor who's working for themselves, that could be considered a firm. I don't believe we define that. So I would like to hear from the board on.
I mean, you're correct. Part of what this flirts with to me is your traditional moonlighting surveyor who's doing a second job off to the side. There's a long history of folks that do that using the equipment and even the personnel from their primary company, but they're working under their own banner somewhere else. One of the things that's not clear to me, although I mean the law clearly says that you can have two firms in one under the same surveyor as the principal surveyor, but they have to be from the same location, which is to prevent folks from opening additional offices somewhere, which is covered somewhere else. If you have an office, there has to be a surveyor in charge of that office that works at least 30 hours a week there. So that keeps them from having one surveyor who's opening up several different offices, which is what I always felt was the intent of it too. So the question here to me is the surveying that he's doing for the construction company. I mean, if it's purely construction stakeout, he's working for the construction company, then that doesn't constitute land surveying and takes that part of it out of it.
Okay.
If they're selling, and I guess this is the key, if they're to the public doesn't eliminate industrial and commercial clients if they are selling land surveying services to industrial and commercial clients, then they may be on that, well, they probably are, I guess. That would be what, to me, would push them onto the bubble where, yes, they are two firms in one place, and he would need to be listed as an officer as the primary surveyor for that company.
Or they have to have somebody else. I mean, one of the two, right? I mean,
they can have two surveyors there, and only, in my opinion, only one of them has to be designated as the primary.
Right. But they have to be an officer or a principal to be the responsible charge
of the company.
Okay.
They don't have to be, again, this is a different subject. I do not feel they have to be the officer to be in responsible charge of the individual survey.
Okay.
But, I mean, that's not what they're talking about here. They're really talking about him. He's to me, somebody's irritated that he's working on the side.
Right.
And the question is, does his primary company actually sell land surveying as opposed to merely construction stakeout?
And I completely agree with you. I think I I would need some guidance on how to figure that out if we want to look further into this. Because I didn't know.
Can we ask that question? I mean, can we
Just ask the company. Do
yeah,
you?
can we defer this, that we need additional information? And to me, the additional information is, I'm not that interested in the clients they work for. I want to know what kind of surveying they are doing under the banner of his main company. Because if it's, if they're going into plants and doing equipment alignment, for example, they could do that and not be. You don't have to be a land surveyor to do that. It's very specialized. You don't have to be a licensed land surveyor to do volumes and construction stakeout that they are building.
Okay.
That's all internal.
Is it, I mean, would they have to be offering to do boundary surveys, or I guess?
That would be the clearest one.
Okay, because I mean, from what I can tell, that is definitely not being offered. I mean,
that would be the clearest one. If they're offering boundary surveys to anybody, yes,
right, and I did not see that. I mean, of course, I looked at their website and read all about them.
But the definition of land surveying goes
beyond that.
It goes a little beyond that when it talks about volumes and grading and things as well.
Okay.
So we, again, there's a fine line there when they're doing it just for their own company for jobs that they are doing, as opposed to doing it, advertising that service out for clients outside of them. I'm not sure how to ask them.
I guess
if I'll toss that back out to.
I'm worried they might not know if they are, because when I look at their website, they definitely aren't offering those services, advertising it. But I worry that if I ask them that, just like he stated, we don't offer land surveying services to the public, they might say no, but they might not clearly understand what that means.
I guess what I'll be looking for then, for them to define to me the difference between what they're considering public and industrial and commercial. Because I'm going to look at it that it's all public. It's just some of them happen to also be. I mean, there's a confusion. People will make the confusion between a private individual and a industry, but both of them are still the public. Is the way, and that's the cloudy point I have right here. But if it's in your own investigation, if you feel confident that they are not advertising to sell surveying services, even the surveying that's beyond land surveying, outside of their company, then that may be sufficient.
Okay, yeah, I tend to agree with most everything Gary stated there. This does seem to me to be a construction company, and a lot of construction companies have their own layout guys, right? They do nothing but construction layout.
Yeah, absolutely.
And most in general are not licensed surveyors, nor do they need to be to perform that service. It's a whole nother discussion, but that's the way it is right now. This guy just happens to be a licensed construction layout guy for a construction company. No problem there. Right now, I'm good. I'm comfortable. The question, I've got two questions. Number one, as a part of his layout services that he performs for this company, again, doesn't have to be licensed, is he laying out property lines? Like a lot of times, construction company would be like, oh yeah, I need that property line staked out so I know to stay away from it, or to put in a water line, or whatever. For some, that's where it's getting kind of cloudy. A little, that would be starting to say, ooh, there's an issue there.
Okay, and that's a better explanation of what I was doing, because yes, if the layout is based off of a property line, then they clearly have to have a licensed surveyor, whether they contract one outside the company or somebody inside to do that particular thing right there.
So again, that kind of gets down to what exactly are the services that you're performing under this construction company. So if it's just general layout of buildings, the equipment, whatever, he's fine. But if he starts getting into staking property lines while he's on the job site, because I don't have to call a licensed surveyor to come in and do that, or in this case, another company to come in and do that to keep that independence, then we've got a little bit of an issue. I do have a question a little bit aside from that topic right there. As an individual, that he is a sole proprietor, not a firm, a corporation, or a partnership. Is he required as that sole proprietor to file a firm disclosure form?
That I don't know.
Does he have one on file?
Would it be separate from his surveying license?
Good. He's got his own side business. completely independent of the construction company, he's got to be the
Would he have to have two license
responsible in
numbers?
charge. No.
No,
Okay.
it's not a license number.
Okay.
But if you have a company, or a firm that's got multiple locations, I mean, the clearest thing, you got a firm that's got multiple locations with surveyors in those different locations, you do have to have somebody who's designated as the officer surveyor of it, and that's the biggest one. There is a question is when you got a company of one, is that really a firm or a company,
Right.
or is it just a guy? But even then, we are required as a board to keep a roster that lists both their business address and their personal address, which is on the website that you can look up everybody. But
And they're given that opportunity when they renew their license as a sole proprietor, at that point, and then to file that disclosure then if they so choose.
So, I should have got an answer there. As a sole proprietor, J. Kaufman Surveying, not incorporated, anything like that, sole proprietor, am I required to have a firm disclosure report? And does this individual in his sole proprietorship have one on file? You need to defer that answer to later. That's fine. I don't expect
I
you to
can
have
look
on
it up
hand.
pretty quickly, or I can defer it to later if you.
I can tell you that in my experience, we operate in a number of states, and even some of the states that are very, very strict with the firm disclosure things, they exempt sole proprietorships because as a sole proprietor, you are the de facto responsible surveyor in charge. So there's nothing to report.
And that's my experience as well in a few of the other states that I'm licensed in, is that they're really aiming for the true companies and not just an individual sole proprietor. And sole proprietor is probably the best explanation of that.
Okay.
But we don't have a question of if they're surveying illegally, right? He's a licensed surveyor and he's working for this company. So it's just whether or not he's in responsible charge and has a firm disclosure for that company to do what they're doing. That's what we're missing here.
Well, if they're actually, what he's just saying is that they're not doing land surveying for the construction company he works for.
Even if they were.
Well, if they were, then I think the question, yes, then they have to, because they are a company, then they do have to have a firm disclosure. In this case, he would probably need to be an officer.
Well, it says an officer or a principal.
Or a principal. There's
I've
a lot
got
of ways. Yeah, there's a lot of ways to do it.
The whole principal thing, I kind of question because, if
be
you're the only licensed land surveyor, kind of by definition, you're the principal surveyor.
Yes.
So,
well, but you're not a principal in the company, and what
but
I
that's
think,
just a
what that
title.
was always written, and the genesis of that, I believe, was they wanted to be sure that the individual surveyor within a company or firm was free from any influence from non-surveyors who happen to be officers. And in this case, I wonder, perhaps it could be as simple as a letter of what's the one that's not
Instruction.
Yeah, which is the one that's not disciplinary, just
Letter of
A
instruction.
letter of instruction.
a letter of instruction saying that we don't think that there's any problem here as long as you're not coming off of boundary lines to do your layout, something to that effect. Because
Performing services that fall under the regulation of land surveying
and I'd give
while employed by the construction company.
and I'd give that one example, anyways. That one right there.
For example, staking property lines. Yeah.
Yeah.
So I think just kind of getting back a little bit, I took us off track a little bit. I apologize. I think getting back to it, I think on the information we have right here, I think he's okay. I'm a little uncomfortable. Again, smoke here.
Yes.
I'm a little uncomfortable, and I like the idea of a letter of instruction just to say, we don't find fault here yet, but to clarify that there is distinct separation between the activities that you perform under the construction company as layout services only, and that those services you perform under the construction company don't fall under the regulation of land surveying as defined, and that you keep that completely separate from your sole proprietorship offering land surveying services, which you can do as a licensed land surveyor.
My feeling is there's nothing wrong here, but I would think it is worth. Here's why we think there's nothing wrong. Please if you're not doing this, then you are wrong.
Right.
Come with it, and I didn't mind to just ignore Kevin down at the end of the table. It was easier when I was sitting next to you, Kevin.
You're not ignoring me. I try to keep things simple in my mind, and when a person doesn't know they're actually doing something wrong, then the rules are probably too complicated. Rules should be such that, all right, I know I did something wrong, and so I'm trying to follow you guys, and I think I'm there with you, but it's a fine line.
That's not a bad comment.
It starts to become a fine line between I did something wrong. I mean, I thought I was working for my company here, so I get it.
It's very much, it's in the kind of the same vein as the engineer, the incidental to your work that engineers have a carve out for. So as long as it's not straying away from that incidental to the work, it's probably fine.
I don't know. I want to get into that. But I know. So what do y'all think? An letter of instruction just kind of saying what we very confusingly laid out for you here.
You have that recorded.
Right. No, I will definitely be going back to this recording to issue this letter if that is what we decide. But I think that is more than appropriate. And then we have it on file that we explained what is allowed and what isn't allowed. And if it were to come up again, we have that record that we instructed him, not disciplined, but instructed.
I think it's important that we think about doing something. I mean, I don't want the complainants to always think that, we just throw these off to the side. I mean, although, to be fair, a lot of them we get in my tenure here that there's just not enough. It's just somebody complaining and they don't have anything in it.
Right.
They won't give us any evidence or anything to work with.
And the nature of the business, it's very, I guess, kind of standard that two surveyors can have differing opinions, and that can cause complaints to come in.
Until you get three surveyors.
Right.
Put them on a board.
Good one.
Okay. Somebody want to put that to a motion, or that we can move on from that one?
I would make the motion for a letter of instruction to be sent to the respondent with the details as discussed.
I like it. Nice and simple. Second. All in favor?
Want to make sure that y'all are comfortable with that. Does that work?
Yes.
I don't want to go into that again.
Yes.
Okay.
All in favor?
Aye.
Okay.
Okay. Number 4, 2023-056-621. And this is pretty similar. The complainant is anonymous and respondent is a licensed surveyor. Complainant alleges respondent works at a company as their licensed surveyor and runs their own business in violation of the rule. Complainant provides no further details or evidence to support these allegations. Respondent began working at an engineering company in April of 2004 as a natural gas designer and civil designer. At that time, the company already had a surveyor of record. Respondent then obtained their surveying license in 2006 and began working for themselves to supplement their income. The surveyor of record then left the engineering company, and respondent by default became their surveyor of record. Respondent works full-time for this company and did not think the rule at issue applied to them because they are not a principal or officer of the company. And then further, this company does not offer to provide land surveying services to the public. Respondent apologizes if they incorrectly interpreted the rule. They do not accept work that would be in conflict with the engineering company. The company is aware that they do land surveying on the side. They have no employees and they are a sole proprietor within their small business. Respondent does state it would be very detrimental to them to quit practicing land surveying because it would take away a significant portion of their income. However, they will accept the board's decision and follow their direction. But it was not intentional if they're in violation. So based on that, I recommend dismissal, but I think based on our prior discussion, I think a letter of instruction would be appropriate here to the same effect.
Yeah,
Exact same thing.
Yeah, it's pretty much exactly the same thing on that. That there, again, this is, and we see this a lot in practice of folks just complaining about the part-time surveyor. of that.
So this one here, I agree. Letter of instruction, all very similar to the prior one. However, the fact that he works for an engineering company, I assume there's civil in there, yes, and civil designer, so I assume that's civil engineering as well. Very similar situation to what I work in. A lot of the surveying that I perform is what I call in-house surveying, right? Our architects, our civil engineers will come to me and say, hey, we got a civil project. I need a full boundary topo of a XYZ property. Great, I'll go do it. Never gets stamped because it's strictly in-house. I'm just producing a boundary and a topo, and I hand it off to my civil designers, and they do their magic. But I am, by definition, surveying, and I have to have a license to perform that, even though I did not offer my services to the public. I did in a secondary fashion, in that probably our marketing department or civil department went out and sold the job to the public. I'm including governmental agencies as well. And then brought it in, and they were like, to the client, they were like, we can handle civil, we can handle surveying, we can handle all that in-house. We're an in-house, one-house shop. So in a roundabout way, the firm did offer surveying services, right? The firm did, maybe not me individually. And I used my license to be able to do those in a legal fashion. But it never gets stamped just because it's not needed for the services requested. I kind of suspect that might be similar here. He or she may be performing land surveying services by definition, going out and doing a little quick boundary topo for his civil designers. He doesn't stamp it, doesn't need to. And then it goes on from there. And then separately and independently, he's got his own business doing surveying. So by definition of surveying, just like the previous one, if they are doing, by definition, surveying at two different locations, it starts to get a little cloudy here all of a sudden. So in this one, very similar to the prior one, but this one here makes me think, oh, there's a better chance here that he is performing surveying services by definition, may not be stamping it, may not be offering it as, hey, we offer business cards with surveying services. It may not be doing that, but is performing, by definition, surveying services. And his license allows him to do that. This one here, again, I still think a letter of instruction is the right course here.
I agree.
But I think there's much more of a chance here of some overlap.
Well, I think what needs to be added to this letter of instruction is the fact that you don't stamp the drawing is irrelevant to whether or not you were doing land surveying.
It's irrelevant.
I mean, it's the fact that it didn't stamp it doesn't change the fact that it needed to be done by a land surveyor.
Okay.
That's the irrelevant part. I think it's exactly what Jay said right there, is that the fact that he's done the survey and it never got stamped doesn't mean it wasn't a survey, and that it had to be done under his supervision as responsible charge.
And if that is the case, am I correct in understanding this rule to mean if that is the case, he cannot continue surveying on the side, or they have to find a new responsible charge surveyor?
Don't think so. We've almost kind of answered that. Is that our initial opinion is that the sole proprietor does not have to be designated as or disclosed as the head of a firm, because he is by himself.
Okay.
In which case he could be fulfilling whatever requirement. I mean, I think the other company does need somebody to be designated as the firm's surveyor. And, I mean, it doesn't have to be all the surveyors that are in the firm. I want to be clear in that. It just has to be one of them to that. And there's a lot of different ways to do that. I mean, you don't have to be designated principal and officer. I mean, you can be a partner, you can own stock. There are different ways that cover that. Whether you want to get into that or not, because I don't know, is that part of the complaint there? These three are running together on me.
So, yeah, the complainant is alleging that because, let's just say, because he believes that this surveyor is acting as a responsible charge at a company and working for himself, therefore he is in violation of the rule.
I would say he's not in violation of that rule, because as the sole proprietor, he doesn't have to.
Okay.
And that would allow us just to quit there. But as to all the rest of the stuff that we said from the other one going, the thing I think is important to add here is that the fact that you don't stamp a drawing is irrelevant to whether you're doing land surveying.
Okay. Like, we want to clear up the misunderstanding that they're not offering land survey services. You are. Doesn't mean you're in violation of rule, but let's clear this up.
Because we get that a lot, and I mean, it's always been a similar situation. Jay says, well, it doesn't count because you're not going to sign it.
Okay.
I said, well, it's an illegal surveyor then because I hadn't stamped it.
Okay. So clear up the misunderstanding that this rule doesn't apply to them. It does apply, but you're not in violation.
Yeah.
Because of these reasons and because as a sole proprietor, you don't need a responsible charge and you're not considered one for your small business.
That's what I was going to ask, if essentially they're clear here because they're a sole proprietor. If they were anything else, would there be a violation? But they're okay because they're a sole proprietor.
That's what I'm
I
understanding.
think we might be conflating two different things, though. I mean, you have to, at a firm, you have to have someone that's designated in responsible charge. You also have to have a surveyor at each office location.
Right.
So it is possible that even though it's a sole proprietor, that doesn't mean he doesn't have people working for him. If he's got field crews running out of another office, he could be in violation then if he's an RLS at two different. So, I mean, we could go down 1,000 roads of what could and couldn't. We just don't have all the information again.
Yeah. Well, and that's true. That's a good point.
But we're making it up at this point.
Yeah, well, the rules don't really
Hypotheticals.
doesn't really help for the only thing in the rule that covers that is that he'd have to have 30 hours at each place, so working 60
Right.
hours.
The previous case that was at the same location,
Yeah.
and that solved that problem. If we don't know in this case if he's got, an office across town.
Yeah, the part-time surveyor is not quite covered in this, I don't think, to that level. So maybe we just don't go into it right there, other than making him aware, like you said, we don't think you're in violation, but you are covered by them, and lay out just what we said. This is why you're covered by them. So moved.
So moved.
Second.
All in favor?
Aye.
Okay, number 5, 2023-055-271. Complainant states they had a survey done in 2017 and alleges no boundary markers were put down other than wooden stakes. Complainant believes survey markers were supposed to be put in the ground with survey caps. Complainant further alleges that the plat was not stamped or signed and they only received a copy. Complainant alleges respondent began a new survey in 2022 and claims it was not completed and is not correct. Respondent provides a copy of the 2017 survey, which clearly shows the corners marked. Respondent states the 2022 survey was done to stake the north line of a property shown on the 2017 survey. Respondent states they were not paid for the 2022 survey. Respondent was then tasked to stake the east portion of the same property, and they found an issue with the deeds for the area. Respondent suggested to complainant and the adjacent landowner that they had two options. One, to work it out between them, and respondent would assist, or to take the matter to court. Respondent states they attempted several times to assist with helping them work it out. Respondent was then tasked to stake road limits, which they did and were not paid for. Complainant then told respondent that the adjacent landowner had moved the corners, so respondent went back to check the corners. Respondent was not paid for this. Respondent met with the complainant at least 3 times in their office, and each time told complainant they could not change the deeds and reminded them of their two options. Respondent ended up filing suit against complainant for non-payment. Respondent confirms they have not completed the survey they began in 2022. The trial took place regarding this suit in November, and the court ruled in respondent's favor regarding all issues, including complainant's allegations that they should, quote, not have to pay for faulty work. The judge further stated that in this country it is common for 2 surveyors to differ on their surveys. Respondent provided a copy of the court's judgment. Complainant then provided a rebuttal where they stated that they, quote, see no issues with the 2022 survey, and other than what they did in 2017. So kind of reaffirming or changing their mind that the problem was with the 2017 survey. So because of that, and there's no evidence of any violations, the statute of limitations and reposed has passed regarding the 2017 survey. So I recommend dismissal.
Go first this time.
Well, I mean, that seems pretty straightforward if the complaint is about a survey that's gone beyond the statute of repose, then there's not much for us to do here. I mean, the question would, gets murky if you start to go down, well, if they were doing a resurvey, does that, reopen that original survey? I don't know, because I don't know what specific issues were encountered. But they're saying there's no problem.
Yeah,
with
then
the
they
new
came
survey.
back and said that,
So-
never mind.
I got nothing.
I'm guessing that's because the court ruled against them.
Yeah, that hurts.
Well, I'm not sure. The 4-year repose is more of a protection against the surveyor from a client suing on damages and things with the survey. It doesn't really protect them from doing lousy work, if that's true. But I mean, I don't see any evidence here that the work was faulty. Just their, it sounds to me like the client just didn't like it. The answer.
I kind of look at it as all that related with the 2022 survey has nothing to do with this. It really doesn't. It's all afterthought. All the didn't get paid, the court judgment, blah, blah, blah. Nothing to do with this. Because we're back up in the original paragraph where the complainant states that boundary markers were not put down other than wooden stakes. That is a violation. That does not comply with what the monumentation rules of what we have. So I'd like to think maybe a letter of instruction might be a good place right there, just to clarify that wooden stakes does not comply with the rules that we have in place. However, the respondent provided the copy which clearly shows the corners marked. Those corners marked, again, in 08-20-03-07, clearly states the way it has to be shown on the plat is an IPF or an IPO. It's an old or found or set. And there has to be a definition of what was set. Now, if he set a wooden stake, that's a problem. If he set, I don't know, an iron pin with cap, the identification cap, or something that does comply, then he's fine. So I guess I would ask for a little clarification on the plat that shows the corners that were marked and that it clearly identifies the material size of the monument that was set on the 2017 plat.
That's a good point. I kind of glossed over that because I've often been called out by people who says, well, the surveyor didn't see anything but wood stakes, and I walk out there and said, yeah, the stake's next to the pin, and show them the pin. It's
Right,
not unusual for them not to see it.
And that's very,
but
the plat should
without
label.
a copy of the plat showing that he had a plat in 2017 that identified them as being set as required and stamped as is required. That's the only opening I see here for a violation.
Right. And the fact that
we don't have that answer to.
Right. And I can't obviously tell if the corners were physically set or not, rather than just labeled and a stake put out there, which would be a violation. But so I guess my question there is I'd like some clarification on the plat as to the corners marked, were they identified as with the material size and type as they should be. In other words, what I would feel comfortable with is if I saw something that said set iron pin with cap, I'd be fine with that. But if it just says set corner, or if it just says set wooden stake, then there's a violation there.
Did they submit a copy? Anybody give you a copy of the plat from 2017?
Just provided a copy. First sentence, second paragraph.
But I also,
Responded, yeah. Okay, there you go.
our statute of limitations kind of prohibits us from doing anything about complaints that are filed related to a survey that's older than 4 years.
That's the same question to legal.
What is the question?
Question was, well, my take on the statute of repose is that that's a protection against the public suing and holding us financially responsible for something after 4 years. So we have a cutoff point with it, but I don't think it protects them from the board in looking and finding that they had been turning out plats that did not meet the rules.
Well, I mean, we have our own statute. I'm not talking about general, the legal definition of statute of repose. I mean, we don't really have a statute of repose laid out in our statutes, but we have a statute of limitations in our statute. So it's pretty clear. It might be something we want to rethink,
Okay. I have not looked at that statute for the surveyors recently. That was just my memory of what and thoughts of what it did. It was more of a protection against the public rather than a protection from a board ruling if something came across their desk and that they truly had been doing substandard work. So I guess that's more of legal direction than if we have the opportunity. Well, you said you do have they submitted the drawing to you?
I'm looking right now.
Because if they submit you a drawing, then you can answer that question.
Yes, I've got it. The plat.
Have a stamp on it.
It says 2006 though, so let me see. That's the only one I have.
That part's easy. If the plat doesn't have a stamp on it, then it needs to have a preliminary or for review only stamp on it.
Okay, sorry, I was looking at the wrong complaint. Okay, I've got it in front of me, and yes, it has a stamp on it. Actually, I'm not seeing a stamp on the one that they provided to me. It's a preliminary survey.
It does say preliminary, so
Yes.
So he's good there. Of course, if it's preliminary, it may not be to the point where they've identified what the corners are. Because one of the reasons to be preliminary is that we've not set the corners yet.
Sorry. Okay, I was looking at the complaint. The respondent is the one that provided the survey. So let me look at his. Provided a copy, but it's not a signed copy. It has a certificate on it, but it's not signed.
Still has to be labeled preliminary then.
I think across the face of the stamp, preliminary only is the way I do it, but
no, it just says
it's not. Okay.
okay. Is a certificate and stamp are different, correct?
Yeah.
Okay, there's no seal or anything. This is just a certificate line that's not signed. So there is no stamp.
Does it have any kind of preliminary?
No.
Okay.
It's just a drawing.
Okay. It's kind of made easy for a letter of instruction here. Just say, you.
Talking about the pen material.
I would just say that your survey has to identify what the corners were set. We could probably even pull.
Well, they may. Of the plat she's looking at, I understand there's no stamp on it, and that's fine. But I guess my second question on that same plat that you're looking at that came from the respondent,
yes.
How are the corners labeled as being set? And it could be a symbol with a reference to the legend.
Well, I see a legend, and I see there's like something that says 1/2 inch rebar with cap.
Okay, all right. And I would assume that symbol in that legend is reference to the actual property line that they claim was marked.
Would be right at.
And then he'd be fine.
It would be at the corner.
Okay. Yes.
Okay. So he's.
And there was there was an allegation in here that a neighbor moved it. So I don't know if they could have been taken up.
Yeah, it's
It's very possible.
But
we hear
there
that
is
a
a
lot.
rebar with cap referenced, and there's a little circle symbol.
We hear that a lot, but then I say 90% of the time I walk up to the wood stake and the pin's underneath the grass next to it. There's just a misunderstanding from the layman. So the only thing that really got onto him is that he forgot to put a preliminary stamp on the unstamped survey.
Yeah, I agree. I think a letter of instruction is appropriate here, with the advising that any issuance of a survey that isn't final to the client, like this, doesn't have a stamp or signature, be clearly labeled as preliminary only, and there is reference in our rules to that.
Yeah.
And
And
I think
it's
that'd
not
be
just
fine.
to the client; it's to anybody, because
Yep. So
it causes damage when we've got these things floating around that folks can misconstrue as being the final survey.
yeah, as far as all the other reference of the 2022 survey and the issues there, again, that's not our business. That's just poor business.
So with that being brought up, I do have a question just to help give me some guidance when I'm writing these legal reports. I put in information that, maybe it doesn't have a bearing on the outcome of this, but I try to, because this is a public document and the complainant, a lot of times complainants want to see what has been presented. I include it so they feel heard. Would the board prefer that I don't include things that may not be relevant?
But my issue has always been that we don't have access to all the information.
Right.
Rather, it's consolidated.
This is highly consolidated.
I prefer the way you're doing it now, because
Is that okay?
that allows me to see additional information, and I can make that decision on myself as to whether it's
Okay.
relative to what we're doing here or not.
Right.
If I were to ask you to consolidate more,
It would be very
I'm
difficult.
contradicting myself. So
Okay.
I prefer more information is better, and allow
Okay.
me to filter out what's the meat on the bone and what's fluff.
Especially
Well,
in such a
I think you're doing a
technical
great job.
industry.
Everyone's different. I get it, and it's difficult especially on your part, as far as what to include, what not to include. I get it, but my answer is going to be the same. The more, the better, and allow me to choose.
Does the complainant get notified that there was a letter of instruction sent out, or
No, they don't get notified.
any result?
I think the only time, they get notified when a matter has been closed. And I think when there's discipline, like a consent order, they don't get a copy of it, but they get notified that this matter resulted in this
In
kind of
reality,
discipline.
These meetings are recorded and are open to the public.
Absolutely.
Okay, so they have that ability to even be listening in if they
Right.
want. Okay, all right.
And they're given contact information with their closure letter, like if you would like to know more. And that happens sometimes.
Yeah, my only concern was I didn't want all the complainants to think that nothing ever gets done with.
Right. No,
Because
yeah.
actually, there's a lot being done here.
Yes, there is. So, I think a letter of instruction is a good result.
Yeah, I'll go ahead and make that motion for a letter of instruction in regard to labeling surveys that are distributed as preliminary in accordance with our rules. And of course, if they're final, that they be stamped and signed and dated with the appropriate certificate.
I think in the law of the rules that they refer to, it says stamp, it says sealed. Just a clarification in terminology.
Okay.
Sealed rather than stamped. We seal them, we don't stamp them.
Okay.
Although we seal them with a rubber stamp. That's
Making it even more confusing.
yeah.
Oh, the plot thickens.
That's where we'll get there. So, all right. So motion.
Second.
All in favor, say aye.
Aye.
Okay.
Okay, that takes us to number 6. I think.
Let me ask: does anybody need a break or?
It's up to you guys.
I'm good.
Good either way.
That's good.
Okay,
We're good. I'm good.
You're good?
Let's just keep rolling.
All right.
You're on a roll. Keep it going.
Okay, number 6, 2023-058-001. Complainant hired respondent to do a survey which was completed in 2006. Complainant filed this complaint because they, quote, want a correction to the survey. Complainant alleges respondent put their corner post 11 feet from the center of the road, but alleges the deed refers to a 50-foot road clearance. Complainant alleges another surveyor completed a new survey and claims the new surveyor thought respondent completed a, quote, bad survey. Complainant alleges respondent is leaving bad surveys all over the mountain. Complainant alleges respondent wasn't licensed when they completed the survey in 2006, although our records show respondent has been licensed since 1970, so that allegation is confirmed to not be correct. Respondent states that all corners were found as set in 2006. The road was gravel at the time and has since been paved. Respondent states the road has shifted a few feet, and respondent states the bearings and distances are correct and match the neighbor's deeds. So our statute of limitations has passed, and our statute, which is, related to a survey that's now 18 years old, and I don't see any evidence of violations, so my recommendation is dismissal.
Turn is to speak
I'll go
first.
I'll go. Never shy.
Sure.
So the complaint as a whole, I agree with dismissal. I'm fine with that. I understand the gravel and asphalt road shifting that absolutely is legitimate. I'm fine there. The only thing that stood out to me was in regards to the quote from the second surveyor that was hired, and stated that had completed that the respondent completed a bad survey, end quote, bad survey. Not professional right there. Not professional. You should not be bad mouthing, so to speak, another surveyor to your client, much less anybody. That was only really my issue, and that was kind of on the second surveyor, kind of an ethics issue there that kind of red flagged. I just want to make mention of it. I don't want to go any further with it. I'm sure there's other details to it involved. Again, it could be hearsay, secondary. I get that. So, but that would be my cautionary point there. Back to the actual subject itself, it makes sense about the road shifting gravel to asphalt. Bearings and distances still match. I don't see any issue there other than if we were to get an expert review on it. But again, being 18 years old, yeah, I think we're past it. So that I would agree with dismissal, but I'm certainly open to other opinions.
Nope, I fully agree with that. It's really old and not enough here to say there was anything done wrong. So I agree with dismissal.
The big problem here is that there's no evidence to deal with. It's all hearsay. Even the fact that the other surveyor said he does bad work is based on the complainant.
Right. He might not have even said that. We don't know.
Yeah, it's all hearsay without anything to back it up for old stuff, and it's very vague hearsay too. So, Kevin,
No comment. I agree.
motion to
A motion to agree with the recommendation from staff for dismissal.
Second.
all in favor say aye.
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 Okay, number 7, 2023059991. Complainant alleges respondent made an error in a survey in August of 2022 and was allegedly informed it was incorrect 7 days after the survey was completed. Complainant further alleges respondent came onto their land without notifying them to complete the survey at issue for an adjacent landowner. Complainant claims respondent designated part of their property as belonging to another person. Complainant alleges respondent admitted they made a mistake and would fix it. So respondent confirms they made a mistake, did admit to the mistake, and has since corrected it. Respondent provided a detailed account of what transpired, the steps they took to correct it, and explained how they misinterpreted a deed which led to the mistake. Respondent took the responsibility as soon as the mistake was discovered and has stayed on top of it. The attorney who is handling the recording of the new deed has communicated this to the lender for signing, so the corrected deed will be recorded. So my opinion is there was a mistake, and it was the surveyor took accountability, fixed it. Therefore, I don't think discipline is appropriate, and I recommend dismissal.
Like you communicated very well.
Right.
Our time too. With
Very
it. So
timely.
There's nothing here about the mistake, and caught it, fixed it, went on. I got nothing.
Yeah, prime example of how to actually handle a mistake. We all make mistakes. This is how you handle it right here. I don't see a violation, quite honestly. I kind of question what the complaint really is. I'm not really sure. It's unfortunate, but I am glad to hear that the respondent was very active in communication, found his own error, brought it to the client, addressed it with recommendations on how to correct it, went through that action. Sounds like it's I don't see anything here, so I agree with the dismissal.
Motion?
So moved.
Second.
All in favor?
Aye.
Aye.
Number 8, 2023-061-731. So the complainant is the Director of Planning for a county planning department. Complainant alleges respondent has been the subject of numerous complaints for many years in the county. Complainant alleges that in the 14 years they have been the director, they have had the occasion to complain to respondent dozens of times regarding their lack of professionalism and seemingly inability to complete a professional survey. Complainant alleges respondent has submitted hundreds of plats and surveys and claims they have not once received a drawing that could be accepted without revision. Complainant admits their expectations can be high because they are a perfectionist, but feels this complaint is not just about the quality of respondent's work. Complainant notes this is also about respondents' professional relationships with customers and other elected and non-elected persons. Complainant alleges respondent was hired by a landowner to produce an elevation certificate because their new home was partially in a flood zone. Complainant was skeptical that respondent was qualified to do the work, but claims respondent convinced the landowner that they could do the work. Complainant alleges respondent has failed on multiple occasions to turn in the work in an acceptable manner. Complainant alleges respondent refuses to return phone calls to the landowner and is many months behind any reasonable time period with no relief in view. Complainant alleges there are other people that have complained to them about respondent not returning calls or completing work. Complainant alleges another city planner told them they caught respondent modifying a plat after it had been signed by the Planning Commission secretary. Complainant alleges both their department and the referenced City Planning Commission changed their policy to require clients to submit checks made out to the Register of Deeds so they can record everyone's plats because of respondent. Complainant claims respondent has helped clients avoid the Planning Commission's review processes. They allege the property assessor, municipal planners, and attorneys all have made similar complaints against respondent. However, the complainant does not provide any documents or surveys or evidence to support these allegations. Respondent obtained their land surveyor's license in 1997, and this is the third complaint filed against respondent in 27 years. The other two complaints were dismissed without action after experts conducted reviews of those surveys at issue in those complaints. So my recommendation is dismissal.
But again, there's a lot of stuff there, but nothing. I really disappoints me that if the register or the head of the planning or the head of the planning staff has legitimate complaints, that I would think that they would be bound under their own rules to protect the public to submit something of substance instead of just talk.
Right.
Glad that they mentioned he was licensed in 1997 because that leaves me out of it, because I don't think I've ever submitted anything to the Planning Commission. They didn't come back with 2 pages of corrections. But usually none of it's got anything to do with land surveying.
That's the point I was going to get to.
Yeah, it's their stuff.
Yeah, their regulations make ours look like a walk in the park. So,
and they have a tendency to interpret even ours to their own, the way they want it to be, or they make their interpretation. So I have a hard time. I'd almost want to kick it back to the complainant and say, if you've got something, send it in.
Right. I mean, because these are really serious allegations made by somebody in a position of power that I feel like if anybody could have evidence, they would. And I realize now, and I apologize for this severely, I did not include the respondent's response in here. I have a detailed response from the respondent. I don't know how I missed that, and I'm so sorry. So if you would like to hear any of that, I'm happy to tell you. Okay.
It's probably similar. He probably starts out with the same things me and Justin have already said.
So it's not that long. I'll try to summarize it. But that, I think it's only fair that we hear from the respondent. So this is what he states. As I've read the complaints piled up against me by the complainant, it doesn't come as a surprise to me, as he and I have not gotten along since the first day I submitted something to the office. The complainant has called me names in the past, and since 2016, I refused to do any work that has to go before any planning commission, not just that county, but some other counties and another city. And the only ones he names certain counties that they work in. And that's because they have a good relationship with those planning directors. The respondent's very well aware that the complainant has complained to them on numerous occasions concerning their professionalism and regarding their paperwork. The respondent states that this complainant expects plats to be turned in a certain way, and after turning in plats to them, they've never received one saying that it should look like this when it gets to my office. Says they've probably turned in 10 to 20 plats over the course of 14 years, not hundreds. And they expect that when they turn it in, it's reviewed and that respondent will be advised of what needs to get fixed. And they say that this complainant always has something negative to say. So that's why they stopped doing work in that city or county. Basically, the respondent just feels like this complainant has it in for them. They make a point to constantly return all phone calls, whether it's nightly. If they do miss a call, they try to get back as soon as they can. And just kind of deny all these false attempts to discredit their reputation. They're very confident in their ability as a registered land surveyor. They approach about 200 surveys per year, and they hope that you can consider their years of service to this admirable institution of land surveying when making a decision regarding this complaint.
Sure.
There's nothing here. There's nothing here. There's nothing here. I mean, we've got our rules and regulations that we can make decisions on, right? Clearly, 0820s. I'm sure planning commissions have theirs, right? I've done many planning commissions. They require extra certificates, extra signatures, blah, 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 above and beyond anything that we have any jurisdiction over. And here is just a bad relationship is what we're hearing. And so the complainant seems to be kind of venting. The one area I do have question in is where it says the complainant does allege another city planner told them, well, right there, second hand, third hand, fourth hand, caught the respondent modifying a plat.
Right.
That I have an issue with. I wouldn't mind if it went further on that, but the meat of what is going on here is just venting. And based on the response where he says, if I understood you correctly, he says he refuses to do work in their county.
Right.
Problem solved right there.
Right.
Let capitalism take its place here. And, if he's doing poor work, people aren't going to hire him anymore to do work. So there is nothing here that I see in our 0820 that we have rules to have jurisdiction on here. I just don't see it. Am I missing it?
I don't think you're missing it, but I sure would like to push back to the complainant to say, again, he has a responsible position. If there's truly something there, he needs to do something more than just vent at us. He needs to send something real that we can give a ruling on.
Well, I would be happy to make a phone call to that effect and let them know that it was discussed. And at this point, it's if you decide to dismiss it, then that's what was done. But we're happy to look at anything if you can present some evidence or something for us to actually investigate.
Yeah, at this point, I would agree with the recommendation of dismissal unless the complainant can provide us with, plats that were submitted, signed stamp plats that were submitted that are in clear violation of our 0820s. Other than that, it's out of our hands. It's not our problem. I mean, can't we all just get along, right?
Well, this surveyor, I took into account how long they've been, surveying, that we've only had 2 complaints, and we had experts look at those surveys, and there was nothing to it. And you would think if it's as bad as this person says it is, we'd get more complaints, or we get a complaint from the client that they reference here. I mean, they're not complaining. The landowner that hired this person.
Motion?
Motion for dismissal.
Second.
Further discussion? And all in favor?
Aye.
Number 9, 2023-064-691. Complainant states they contacted a respondent on July 9th of last year via text to ask about surveying 2 separate properties. Respondent informed complainant they were very busy and to try back in the late summer or fall. Complainant followed up in late September and claims they were told it would be $1,000 for the survey and it would include a map and filing. Complainant states they met respondent on September 26th and paid them. Respondent explained there were some issues with the lot lines that they would clear up. Complainant attempted to get a copy of their neighbor's map per respondent's request, but they were not able to provide one. Complainant states respondent has not communicated with them and was out of town when they tried to follow up. Complainant wants a refund so they can hire another surveyor to complete the job. Respondent confirms they met with complainant at the property, and after examining it and finding no property corners, they informed the complainant that more research would be required. Respondent denies giving complainant a completion time. Respondent told complainant that there may be an encroachment at the rear of the property, but complainant wanted respondent to just supply them with a plat that showed no encroachment. Respondent explained that would be unethical without performing the survey. Respondent states complainant insisted on paying them before they completed the survey, but respondent did not want to accept the payment until they were finished. Respondent got in their truck to leave, and complainant proceeded to give a check for payment in full to respondent's secretary. Respondent has since given a full refund to complainant and provided a copy to me. So I don't find any evidence of violations, and I recommend dismissal.
I don't see anything here.
Again, poor communication, poor business, and it sounds like a lack of contract. That's what it sounds like. I didn't see any mention of whether it was or wasn't, but certainly sounds like there wasn't with, clearly defined scope, clearly defined date of delivery, et cetera, et cetera. There's nothing here. So
No, I agree.
make a motion for dismissal.
Second.
Further discussion? Favor?
Aye.
Okay, last one. Number 10 is 2024-000-321. Complainant states respondent was hired many months ago to survey land for the partition of their father's estate. Complainant alleges respondent has been very unproductive and only produced one of the 4 surveys which they were hired to complete. Respondent confirms they were contacted in March of 2023 by the executor of the estate of the complainant's father. Respondent met with the executor and was asked to survey 4 separate parcels of property to be deeded to various heirs. Respondent does not normally take jobs that are this far away from where they live, but agreed to help because the executor is related to them by marriage. And respondent assumed they were having a hard time finding anyone in their area. Respondent then suffered a stroke in April and was diagnosed with diabetes. In the following months, as respondent was physically able, they met with the executor on numerous occasions to work on the property survey until the executor began having health issues. And then I actually spoke to the respondent recently just to kind of get more clarification on this, and the executor is in a position where they can't even speak. I don't know if they have a tube but they're unable to talk, and they are the ones that hired respondent. Respondent doesn't even have complainant's contact information, never met him, doesn't even know what he looks like. So the respondent just kind of explained like they were willing to finish this, but nobody's talking to them. This complaint just kind of came out of nowhere. But they're willing, if the complainant wants somebody else to do it, that's fine. I asked if you've been paid for anything that you haven't done, and the respondent said no. So based on that information, and there's been no complaint by anyone in the family that actually hired respondent. I just didn't find any evidence of violations and recommend dismissal.
And I agree. I don't see anything here other than the respondent unfortunately got involved in a very complex family situation.
Yes.
But I don't see that he's done anything wrong. Sounds like he's done his best to accommodate a complex situation not of his making.
I agree.
Yep, I agree.
Yep, I agree.
Make a motion for dismissal.
Second.
All in favor?
Aye.
Aye.
Okay.
That concludes the legal report.
All right. Where does that leave us? New business?
I didn't have anything. So then PDHs then.
That's right. This is where we're left in is what we got here. Our mark or just an hour and a half?
Hour and a half's where I'm at.
Okay.
So,
PDHs, 1.5 PDHs?
I mean, well, PDHs are typically 50-minute increments, so you could do two PDHs.
Probably including the homework involved, I would probably round it up to 2.
Okay. Is that a motion?
It's a motion.
Do I have a second?
Second.
All in favor?
Aye.
Aye.
All right.
Then can we entertain a motion to adjourn at this point?
Or you can, since you've already approved the agenda, you could adjourn if you like, or you can entertain a motion if you just want that extra support.
We stand adjourned.
All right, sounds good. Thank you, sir.